Good morning, everyone. Let's get started. I am Louisa Heiny. I am the Associate Dean for Academic Affairs and a professor here at the University of Utah S.J. Quinney College of Law. And it's my pleasure to host our Dean's Book Talk today. Dean Cronk-Warner was unable to join us, and so I have the pleasure of filling in. With me are three panelists today. First, we have Christine Durham. Christine Durham is the former Chief Justice of the Utah Supreme Court and the first woman to serve on that court and on the General Jurisdiction Trial Court in Utah. She was reported by the national press as being a candidate considered for the U.S. Supreme Court vacancy that was eventually filled by Justice Ruth Bader Ginsburg. Since her retirement from the Utah Supreme Court, she has been practicing appellate law in Utah, and she retired in 2017. She has been working for diversity and inclusion in the courts and in the legal profession her entire year. Next, we have our author today, Hannah Brenner Johnson. She is the Vice Dean for Academic Affairs and a professor of law at California Western School of Law. She teaches courses all across the law school curriculum, including torts, gender, power, law, and leadership, and a seminar for the clinical externship. Her research interests focus broadly on the intersection between law and gender, specifically on sexual violence that occurs in closed institutional systems and gender equality in the legal profession. She is the author of 2 books, including the book that we are talking about today, numerous articles, and book chapters. Her work is widely cited by the courts, legal scholars, and by the media. Earlier in her professional career, she served as the first executive director of the Center for Women in Law at the University of Texas School of Law, and we are delighted to have her joining us today. Finally, our third panelist is Margaret Plain. Margaret Plain is the city attorney for the Park City Municipal Corporation. I am delighted that she is a professor with us at the University of Utah S.J. Quinney College of Law. Last fall, she taught state and local government as an adjunct professor with us to rave reviews. Prior to joining Park City, Ms. Plain served 2 mayors as the city attorney for Salt Lake City Corporation and was the legal director for the American Civil Liberties Union of Utah, where she litigated civil liberties cases and directed the local organization's lobbying efforts for 3 years. She's a member of the Utah Judicial Council and serves on the Utah Supreme Court's Oversight Committee for the Office of Professional Conduct. She was president of the Women Lawyers of Utah, House Delegate to the American Bar Association's policymaking body, the House of Delegates, for 10 years, president of the Alden J. Anderson America Inns of Court, and co-chair of the Utah Supreme Court Committee on our new lawyer training program here in Utah. She's been recognized as a mentor for the Women's Law Association, the Young Lawyer of the Year, fellow in the American Bar Association, and the Christine M. Durham Women Lawyer of the Year. After graduating from our law school at the University of Colorado, she clerked for the Honorable Judge Pamela Greenwood on the Utah Court of Appeals. And during law school, she served as managing editor of the Journal of Land Resources and Environmental Law. She has a bachelor's degree cum laude in philosophy and German from Rawlings College in Florida and a master's degree in philosophy, again, from the University of Utah. So welcome to all of our panelists. I'd like to start for the non-lawyers or non-legal wonks and ask about the nomination process for the Supreme Court. Our book today, Shortlisted, Women in the Shadows of the Supreme Court, looks at women who have been shortlisted or even nominated for that position and then not eventually chosen. Justice Durham, could you explain the nomination process for a Supreme Court justice?
I'd be happy to. In the federal system, and of course everyone should remember that the federal system is governed by the federal Constitution. In each of the states, on state high courts, each state has its own system, so it's not consistent throughout the states. But for the United States Supreme Court, the Constitution provides that the president shall nominate and the Senate shall give consent and advice, which essentially means confirmation. And the Constitution says nothing more specific about the process. So presidents have, over the history of the process, devised their own methods for doing that. What has evolved for the last probably 30, 40 years is a system whereby the president consults with, well, and this has probably always been true, consults with advisors and close associates and puts together and then has researched names of people that appear to be eligible for the court. A number of years ago, at a time when the president in question, and this is in Hannah's book, had connections with the leadership of the American Bar Association, the presidents began to, on occasion, ask the American Bar Association to give a rating on the names that the president submitted. It didn't have any binding power, but the ABA developed its own system of highly qualified, qualified, and not qualified, and would send those ratings to the president. The presidents usually used those to further their own interests. In other words, they were hoping and expecting for cover in various kinds of settings. Over the history of that relationship, it has gone sour from time to time. And President Trump, for example, and other presidents before him at various points said, I don't want to hear from the ABA, none of their business, I'll go ahead with my process. But it's back in play now, and I'm sure Hannah will have more to say about that. But with the ABA ratings and frankly, I learned from Hannah's book, something a process I did not know about, and that's the degree of lobbying that goes on sometimes through the president's advisors, sometimes directly to the president, by all sorts of people, including on occasion sitting members of the United States Supreme Court. After the president finally makes a decision and announces it, then comes the confirmation by the Senate process. And that has evolved into formal hearings. We've just been treated to a perfectly disastrous example of what they've become in the recent confirmation hearings for the latest nominee of the president. Then the Senate, majority of the Senate have to vote to confirm, and then the person's in office. I hope that wasn't too long, but it's a fascinating process, as you can see from reading the book.
That's very helpful. Hannah, I think it would have been easy to write a book about our sitting Supreme Court justices. Why did you decide to write about shortlisted women instead?
So to talk about the origins of the book requires me to go back over a decade in time. You all may remember President Obama had the occasion to fill several vacancies on the Supreme Court. He put 2 women on the court, now Justices Sotomayor and Kagan. And back at that time, my co-author, Renee Kanaki Jefferson, and I were colleagues together at Michigan State University College of Law. We were really just engaging in hallway chatter, right? We were reading the headlines about the nominations. Of course, it was exciting. It was an exciting time to see not just women, but a woman of color be considered for the court. But we were a bit stunned and offended by the way that the media at that time was covering these nominations. They were focusing on things unrelated to the qualifications of these 2 extraordinary women, focusing on their appearance, the fact that they were single, It was highly suspicious that neither of them had children. And we continued to observe these repeated themes in the coverage of these two women. And so as academics, of course, we have a lot of power and privilege. We can do more than just complain. We can engage in research and study. And that is what we did. And so we started on a very lengthy empirical research study, a content analysis of over 4,000 newspaper articles that had been written about the Supreme Court nominees dating back to the early 70s. We wanted a comparative study of men and women. Of course, there weren't that many women who had been on the court at that time. And you may be wondering, okay, you asked a question and this has nothing to do with writing the book, but I'm going to get there, I promise. So we read 4,000 articles. We coded each article for over 50 variables, trying to understand the way that not just media was handling and addressing these nominees, but as a reflection of what actually was happening on the ground. We thought that the media was really translating a lot of the bias, stereotypes, discrimination that women in the legal profession and beyond faced. Embedded in this literal stack of 4,000 newspaper articles was a piece written in the early 1970s, published in the New York Times. It was written about two women. We had not heard of either one, Judge Mildred Lilly, who was a judge from California, and Judge Sylvia Bacon, who was a judge from Washington, D.C. These two women appeared on President Nixon's shortlist for the United States Supreme Court. Now, we were stunned, of course, by that fact, and that actually is what led us to write the book. But the article itself was also interesting. It commented on Judge Lilly, noting that she looked great in a bathing suit. In fact, the article quoted her as maintaining a bathing beauty figure, and also noted that it was fortunate that she had no children. Now, this was the 70s, sexism was extremely explicit and pervasive, although the media coverage was not that different from what we had observed during the nominations of Justices Kagan and Sotomayor. And so we were outraged, of course, by the sexist coverage, but more importantly to this project, we were just, I think, stunned that there had been women before Sandra Day O'Connor became the first to be confirmed to the United States Supreme Court who had been shortlisted. And so this began our research question. Well, if we had never heard of Judge Lilly and Judge Bacon, and these were very qualified women that Nixon had put on his shortlist, who else might be hiding in the shadows, hence the name of the book, that we did not know. And so we embarked on a very extensive, almost decade-long research and writing project. As Justice Durham noted, the process of shortlisting has been, kind of evolved over time. Unfortunately, there is no list that a researcher can consult about who has appeared on a presidential shortlist. And so it actually required us digging through presidential archives, relying on the research of other scholars to put together a list that includes 9 women dating back to the early 1930s who were shortlisted but never selected to the Supreme Court until, of course, Sandra Day O'Connor became the first. So that's really the backstory of the book.
And I was so surprised. I thought we were going to pick up the thread maybe at Kennedy at best. But I opened the book and there's Herbert Hoover, which was very surprising to me. How did you decide when you'd reach the end of the thread?
Well, at some point you have to draw a line in the sand, and we did. I do think that we accurately discovered that Florence Allen, a judge from the state of Ohio, who was the first woman to achieve so many firsts, including she was the first woman appointed to the Sixth Circuit Court of Appeals, or any federal appellate court for that matter. She was shortlisted by. We first discovered by President Roosevelt. So we actually have a list from his archives listing, maybe 15 names or so. And Judge Florence Allen from Ohio is included on that list as possible contenders for the court. Our research also revealed that President Hoover also considered her. We found similar documentation in his archives, as did President Truman after FDR. Truman actually seemed very amenable to putting Florence Allen on the court, but when he consulted with those sitting justices at the time, discovered that Justice Vinson and others were deeply uncomfortable at the idea of a woman being among them. For, how on earth would they be able to put their feet up on the desks and loosen their neckties in the presence of a woman. But I want to pick up on a thread that that Justice Durham mentioned a few moments ago about the heavy lobbying, because although Florence Allen appeared, was shortlisted by these three presidents, the lobbying efforts began actually even a decade before that. We uncovered a letter written from just a constituent in Indiana to President Coolidge, asking him to seriously consider Judge Allen for a position on the U.S. Supreme Court. So she was a trailblazer, and I'm happy to talk more about her, any of the women, as our conversation evolves.
I found the lobbying particularly interesting as well. You talked about some positive lobbying, some negative lobbying, from dinner table lobbying by the wives of presidents. Famously, Marty Ginsburg lobbied behind the scenes for his wife, Ruth Bader Ginsburg. I was really surprised by the degree to which the sitting justices involved themselves. Margaret, were there any surprises for you on the question of lobbying efforts by various constituents?
Well, to your point, I was also very surprised by the active role that sitting justices took in discussing directly with the president or whoever the president had put in charge of his sort of nomination process, whether it was the White House counsel or Attorney General. I thought, sort of back to the vignette that Hannah just mentioned, with sort of going back to Chief Justice Vinson and asking, well, what do you think about putting a woman on the court? And that answer coming back very directly that, that just wouldn't do. And I think the same sort of vignette was repeated when Nixon was president, if that's accurate, that he also reached out to the Chief Justice at the time and was told, we're not really in favor of a woman on the court. And Nixon seemed to have responded by saying, neither am I. And some of the information that these wonderful authors have in the book about from the Nixon tapes, I assume, were just, they shouldn't be startling, but they were startling to me in terms of Nixon saying, I don't even think women should have the right to vote, but because they do, I need them to vote for me. And therefore, let's see what we can do about the woman problem, which is the problem that women were lobbying Nixon to appoint a woman to the court. He wasn't in favor of it. The Chief Justice wasn't in favor of it. And he looks to have sort of come up with a strategy to both get credit for putting women forward, Mildred Lilly and Bacon, I can't think of her first name. Sylvia Bacon, putting both of those names forward. And that's where he sort of engaged the ABA committee that Justice Durham mentioned to frankly sabotage Mildred Lilly. And I just want to make a quick comment on the ABA committee because I did serve in the ABA's House of Delegates for 10 years on behalf of Utah, the state bar, and then as the elected delegate. And, my impression is that the ABA guards that vetting process very jealously. They're very proud of it. They guard it very jealously. And when I read, sort of the history of that process, that it goes back to Eisenhower in the 50s, I was pleased. But then, of course, when I read that, as late as Nixon's presidency, how it was still 11 men, frankly, from big law and a very small segment of the legal community, Nixon successfully used the committee to sabotage it. And although Mildred Lilly had been on the bench for 20 years at the time he sent her name to the ABA committee for, secret pre-vetting, the ABA committee ruled her or voted her to be not qualified by, I think, a 10-1 vote. That information was leaked to the press. And so Nixon got to have it both ways. He both put forward a woman as a favorite and then managed to sabotage her through this incredibly powerful committee of 11 white men from big firms who weren't accountable for their discussions or their process with any sort of transparency. Now, that said, you all mentioned that the committee has sort of waxed and waned over the years in terms of how presidents use it. And, at different times, progressives have supported the committee and opposed it, and the same is true, of course, for conservatives. And currently, President Biden is using the committee in the same way that President Trump did, which is to say, he is not using the ABA committee to pre-vet potential nominees. Instead, he's making nominations like President Trump did before him, and then sort of allowing the ABA to weigh in. So it has certainly changed president to president in terms of whether they use it at all, how they use it, whether it's pre-vetting, and the criticism waxes and wanes from, it's too much big law to it's not transparent and other things. So I point that out. And I should also say that I think the ABA committee of the 1950s and the 1970s is very different from what it is today. The current chair of that committee is a minority woman, a retired judge. Judge Williams, who I've met, was the first woman of color to serve on a district court in the 7th Circuit, I think. And so the committee has certainly diversified, although I do think that you look at the number of hours those individuals have to put into it, and it would be very hard, for instance, for someone in my position as the chief counsel to a local government organization to devote the kind of time and energy. And so big law and big law professors that have the support and the ability to do that kind of work still tend to dominate. So
sorry, go ahead, Hannah.
I was just saying, and there was no diversity on that committee in the 1970s when Mildred Lilly's name went before it. And I just want to note that years later, former White House counsel John Dean took the qualifications of Judge Lilly and wrote a really interesting piece comparing them to Justice O'Connor, and came out, concluding that the two women were equally qualified, if Mildred Lilly might have been even a little bit more qualified than O'Connor in his assessment. So I do think that the deep vestiges of sexism were probably at play, in addition to some of the other dynamics that you identify about that committee. And it is fortunate that we have evolved to a place where that committee now reflects the legal profession and its diversity.
I want to invite anyone who has joined us to leave questions in the Q&A section that you'll find at the very bottom of your screen. I'll be moderating those questions, and we'd love to have you join our conversation. Christine, Hannah mentioned a little bit some of the press that some of our shortlisted women received, and the kind of commentary in the press about their looks, whether they were good cooks, what their hair looked like. I was a little appalled at the commentary about the choice of undergarments for at least one of our shortlisted women. But one thing I hadn't really thought about was the issue of age. Hannah talks about this towards the end of the book, and the idea that as some of the nominees or potential nominees, were considered too old, some were too young. And I love the quote that she chose, that men are expected to age into power and women are expected to age into obscurity. Thoughts, Christine, on that?
Well, and that's a double-edged sword as well, because if you're too young, then you're immature. Young men are ambitious and on the way up, and young women are immature and needing more time in the workplace. So it really has been historically that women have met barriers of stereotypes and expectations, no matter where they stand in the ranks. I think that has changed. I actually remember when I was appointed to our court, the press was all about the fact that I was the first woman and didn't mention my age, which was very fortunate for me because I was very young. So sometimes gender can be used against age, but more often age is used against gender.
Hannah, the same or similar question about motherhood. Mm-hmm. Some of our women in the book are unmarried or don't have children. That seems a little suspect. and some are married with children. And probably you can't do the job if you're supposed to be a stay-at-home mom taking care of your kids and your husband. Can you talk about that double-edged sword a little bit?
Sure. Well, we've certainly seen that play out in contemporary Supreme Court appointments, most recently with Justice Barrett, I think being viewed again with suspicion. How can you, she's almost too much of a mother, as a mother of 7 children, and was scrutinized for that. She also, just as a note, was the only Supreme Court nominee, to my knowledge, who was asked during her Senate confirmation hearings who did the laundry in her home. And you contrast her with Judge Jackson. There's been not that much coverage of her status of a mother. And then, of course, the first two women to be on the court really fit the married heterosexual norm, mothers with children. But the women who were shortlisted but never selected, I mean, all of their stories are so very different. I think about somebody like Susie Sharp, who sat on the North Carolina Supreme Court, the first in her state. And she did not believe that women could do both. So she was very much somebody who adhered to this notion of separate spheres, that women belonged at work or they belonged at home. She never married. She did have long-standing relationships with male attorneys throughout her career, but never had a family and never got married. And so, I think one of the takeaways for me is that there are so many paths, right? Some of us have children, some of us are divorced, others have remained childless, and it's not a proxy for our qualification to succeed or to make it into the upper echelons of power. That there are, and I suppose this is a reflection of the importance of diversity on any court or in any workplace, that there are so many different ways to get where we ultimately might want to go.
Well, and I would just add to Hannah's comment that it illustrates the degree to which it isn't just men who absorb the stereotypes and expectations based on gender, it's women as well. And I think there were generations of women who believed with Susie Sharp that you couldn't do it all, that if you wanted a career, you had to forego family ties and connections to some degree. And one of the things I've always believed was so important in the fight for gender equality was the notion that women could become individuals, that they could shape their own standards or their own paths and not be governed in any way by other people's expectations. That said, of course, then they face the hurdles in whatever generation of getting past the assumptions of the selectors and the people who were doing the nominating and the appointments.
Well, although if I may, I think the comparing and contrasting of Florence Allen and her work for suffrage, right? How else could she have gathered the tens of thousands of signatures from all the counties in Ohio in the early 1900s if she hadn't been involved in the suffrage movement? And so in that case, even though the men had the vote, she leveraged her network of women that she had developed through the suffrage movement to get on the ballot, and then ultimately was elected. And you compare that with Susie Sharp, who you were just talking about, Christine, in terms of she was so adamantly opposed to the Equal Rights Amendment. She was already on the bench, and I believe she lobbied against against the ERA.
Yes.
While she was on the bench.
Yeah, I was in North Carolina for the ratification fight. Yes. And yes, she did.
And I've heard you talk about that and wondered if that was that same time period. So that's a really interesting sort of juxtaposition.
But Margaret and Hannah, you're both teachers, you're both mentoring the next generation of young female attorneys. Our law school is now majority female in every way. Every entering class is majority female. The law school is, the senior administrative staff is. Do you see younger women who are coming up in the legal profession as self-shortlisting or buying into some of those stereotypes?
I do. I see it among my immediate peers. I see it among my students. And I think naming it, calling it out, challenging one another about it. My co-author and I talk about this all the time. We ourselves have self-shortlisted for different opportunities. And, I think the path forward is recognizing it for what it is. At the same time, success doesn't mean the same thing for every one of us. So we don't all need to be, appointed to the, to the highest court, or, most of us won't be Supreme Court justices, or, managing partners of law firms, et cetera. So I think it's important that we maintain our own authenticity, determine what makes the most sense. And this is certainly advice that I give to our students. But to the extent that our students or all of us allow, our own self-doubt. My colleague, Leslie Culver, or former colleague Leslie Culver, who is now a faculty member at Utah, writes a lot about imposter syndrome and identity issues and self-shortlisting and self-sidelining. And so I think it's important to name it and see it for what it is and transcend it when we can.
I agree with everything Hannah just said, and I want to point out, Christine Durham was my state constitutional law professor when I was at the U, and has certainly been, a mentor and an advocate and a champion for me throughout my career. The young women that I've had the honor of working with through the Utah Bar's mentoring program, and then also through teaching at the law school, I do think there is still this sort of pernicious tendency to say, well, it's too soon for me, or I need to wait.
Yes.
And it goes back to that balance of, are you too young or are you too old? And that window feels shorter sometimes for women and minorities than I think it does for men, based on sort of dominant expectations. And so while we do all have our own ambitions and our own paths that we want to take to get there, I think there is an ongoing tendency to opt out sooner, or believe women and minorities, we tend to believe we need more qualifications than others do to apply for something. The other thing that concerns me is we've gotten, the conversation, has really evolved. We're not talking about bathing beauty figures or Mary Tyler Moore smiles when we talk about women on shortlist, or women who are applying for jobs in the boardroom or on the law firm committee or for the bench. Instead, the language is much more carefully crafted and potentially less gendered and less, sort of race-based, which creates a different set of problems because—
It's code. Yeah.
Thank you. You can say that.
Yeah.
Christine,
Well,
can you give an example of that code?
It's so subtle. It has to do with the kind of adjectives that are used to describe people. So, for example, whereas someone might be described as energetic and ambitious, another might be described as, somewhat reserved and perhaps a little quiet in some settings. I mean, it really is very subtle, but if you parse the language, you can see it. And I really agree with Margaret's comments about women's, and the comments that Hannah's made about self-sidelining. I sat, when I was on the court, I sat on the, as a member, non-voting member of we have a nominating commission, a nonpartisan nominating commission that reviews applications for the bench. And we were entitled to recruit for people to apply. And so over the years, I spent a lot of time trying to convince women and minorities to apply. And particularly with women, there was often this reaction, oh, no, I'm not ready for that. I don't have enough experience yet, et cetera, et cetera. I never once encountered that in the recruitment of a male candidate. And some of the male candidates, I mean, the fact that they had the, the self-confidence or maybe the hubris to apply on occasion was startling to me, when there were these incredible women who didn't think they were ready. So something's still going on in the socialization and the vocabulary around gender, and it happens around race and ethnicity as well. There's no question, and certainly around disability. That's another huge problem.
Margaret, you had mentioned the garnering of votes, particularly with some of our very early justices and judges. But when Christine was explaining the nomination process, we she mentioned states are different. Can you talk a little bit, this is a question in our Q&A, about the various systems that we see with the nomination process, the election as opposed to the executive nomination, and what your thoughts are on which is better, or maybe the answer is they're just different in creating diverse benches?
No, some are better.
Yeah, I was going to say, I can easily say that I think a system where judges are elected is the worst of the possible systems. I think that, I don't live in a state where that, and, Utah has sort of a hybrid, right? It has a merit selection process, Utah likes to call it, where there is a nominating commission. People have to apply. So you fill out the application, the nominating commission receives those applications. They can conduct their own interviews in Utah, and they interview the candidates, and then they issue a list of nominees. The number of nominees that the commissions need to name is defined by statute in Utah. And so it's a 5-member list for the district court bench, 7-member list for the 2 appellate benches. But that's all statutorily determined. The state constitution, though, does require this nomination process, which I think is a very good one, and Utah is very proud of it. And I'll be the first to tell you it doesn't always work, but it's a good process. The states, but in Utah, the reason I said it's sort of a hybrid is because once you're on the bench, you then stand for retention elections. And I'm sure lots of people listening have had family members and non-lawyer colleagues, and maybe even lawyer colleagues, say to them, how do I know which judges to vote for? How do I know which judges to retain? And fortunately, Utah has a pretty great system with this Judicial Evaluation Committee that now puts out pretty robust information through surveys of those who have appeared in front of the judges, those who have attended hearings and observed. And for the active voter, there's a lot of information out there that can be gleaned in order to determine how to vote for retention. But the straight up election system that exists in a lot of states, it just changes that dynamic in terms of political favors and money in the election of judges. And, my mom lives in Florida and always calls me and says, how do I figure this out? And it really changes the dynamic. And so I think that of the different processes that vary state by state, again, Utah has a pretty good one for people who are interested in getting involved. The nominating commissions are selected both through nominations that come from the Utah Bar Commission and then go to the governor. And then the governor also has direct appointments to those committees. And those committees really do yeoman's work. They interview a lot of people, review a lot of material, and it's important. I guess the other thing I would say is in Utah, it is still a very political process, because once you get on that list, and I've been shortlisted at every level of court in Utah, and I'm grateful for that. And as the book says, it's an honor. But of course, being shortlisted isn't the end game. And once you make it that far, then you still need to be appointed by the governor. And once you're appointed, you still need to get through the Senate hearing and confirmation process. And in Utah, we have 29 senators. Currently, 25, I believe, of those senators are in the majority party. And right now, one of those senators in the majority party is a woman. And so when my appointment went to that committee, I believe there was at least one more because the lieutenant governor was still in the Senate then. So there was 2 or 3 of the 25 were women, and one of those women was in the hospital, and that supermajority gets to meet behind closed doors and make decisions, including whether or not to hold a hearing. And so that's where the process is inherently a political process, and in my case, it fell apart.
Well,
There have been other very discouraging cases in which it has fallen apart at the Senate level. We didn't always have Senate confirmation, and I liked it better before we did, but they didn't ask me when they changed it.
I do want to echo what Margaret said, that being on the short list is not the end game. Short lists are used often very politically, right? People, presidents, others have no intention of moving anybody off of the list sometimes. It can be a way to check the diversity box, but not actually have to deliver on producing or selecting a diverse candidate. But also want to echo what you acknowledged, and I think it's really important that, you know, of the women in the book who were shortlisted, you can't look at their credentials, and certainly this is true of you, Margaret, as well. You know, that they were not, or you were not taken off of the short list and selected does not in any way discredit the incredible accomplishments that women have made. And it is often things outside of qualification that actually prevent individuals from moving off of that list. So I just think that is a really important thing to point out.
And I'll just, sorry, go ahead, Hannah.
No, go ahead.
I was just going to say one thing that, you know, we saw President Biden do is, you know, if you want minorities or women to make it off the short list, give a short list of all women who are minorities, and bingo.
Absolutely. Well, I mean, that's a really interesting conversation point as well. Certainly, President Biden was not the first president to make a campaign promise to put somebody on the court. We, of course, recall President Reagan did something very similar when he was governor and campaigning for president, promised that if a vacancy occurred on the court, he would deliver a woman. He did give us Justice O'Connor. He did not do much to diversify the bench otherwise, and was really called out in a lot of different contexts for that. And even President Kennedy had promised to diversify the bench, of course, wasn't given much of an opportunity. He did appoint one woman, Sarah Hughes, from the state of Texas during his short time in office. But, you know, President Biden's commitment to put a Black woman on the court, of course, as you know, it was made easier because his shortlist was comprised of an incredibly qualified group of Black women. I have no idea how he made that selection. They were all of the women whose names we reviewed were extraordinary. And I think Judge Jackson was an excellent choice. But President Reagan, in promising to put a woman on the court, I think it's important to note, meant a white woman in all likelihood. Although there was one woman of color in our study of 9 shortlisted women, Amalia Kearse, who is on the Second Circuit Court of Appeals, currently in senior status, who was shortlisted by presidents crossing partisan and political lines. If you can imagine that, our Supreme Court selection process today is so heavily dominated by politics, as it has been over time. But when you think back to the unanimous confirmation of Sandra Day O'Connor in 1981, with what we are expecting with the confirmation of Judge Jackson in a few weeks, could not be different. And so that range of politicization has certainly varied over time.
And I think it's worth pointing out from the book that the work that President Carter did. I mean, compare Kennedy, who I think signed legislation that created like 50 new federal vacancies throughout the nation. And then in his 3 years, he only managed to appoint one woman. Carter never had the opportunity to appoint anyone to the US Supreme Court, but he, back to the nominating question you asked me, Louisa, he did change the system. He created nominating commissions throughout the federal circuits that were specifically instructed to consider, you know, minority candidates, women candidates, to ask nominees or people they were considering those hard questions about diversity and inclusion. And Carter's doing that really did sort of change the discussion, and hopefully, didn't he appoint more women than any other president or any president before him, certainly, but that wasn't hard.
Right. And,
Low
and
bar.
we often overlook him, of course, because he didn't have a vacancy on the Supreme Court, but he did so much to diversify the judiciary. And importantly, through the judicial nominating commissions that he created by executive order, filled the pipeline with diverse judges from whom presidents who followed him could then select. And so that's really an important, it was very, very important. And I think he gets should get a lot of credit for.
Yes, he should. And there's another phenomenon that was going on. I don't want to take too much credit for it because I don't really have a way of assessing the inside impact. But in 1979, there was a convocation of all of the women judges that could be located across the country in Los Angeles, California, and the National Association of Women Judges was formed. And that one of the first focuses of that organization was to expand the number of women on the federal bench. And particularly when Carter came in, the people from NAWJ spent a lot of time and effort educating the White House, the people who were working on nominations, contributing to shortlists, and so on. And I think that had, well, the story that Cornelia Kennedy is quoted in your book, I was there for that occasion. I actually remember Berger's comment a little differently. She said, you know, are all of you, well, this is the one where Berger came into a reception for the National Association of Women Judges. There were 200 of us there. And he walked in and he really looked dumbfounded. She remembers him saying, I think, are all of you really judges? I remember him saying, are all of you ladies really judges? So she may be correct and I may be correct, but it, you know, I think just the existence of that organization and the work it was doing had some impact on raising awareness.
You mentioned, you all talked a little bit about President Reagan getting credit for putting, and most famously credit for putting our first woman justice on the Supreme Court, and then quietly filling the rest of the federal coffers with men. I want to say 4% women, something like, Hannah, you can correct me on those numbers. You mentioned tokenism, having one woman and being able to say, look, I put a woman on the bench, and the degree to which tokenism might actually enforce the status quo in some ways rather than moving us forward. Hannah, could you talk a little bit about that?
Sure. Well, you know, once the diversity box is checked, to the extent that you are making that selection just to satisfy your constituent base or whoever, it's very easy to just sort of then decide that you're done. We're all also subject to bias, and there's actually a phenomenon called visibility bias, where we look at, let's say a court, and we see a woman of color on the court, and we assume that then the court is diverse, or the diversity is being addressed. And so I think that often has been the case. I think less so today. We talk a lot, though, in the book about the harm of tokenism and how difficult it can be to be the only woman, the only woman of color, for so many reasons. I mean, it's isolating. There's a lot of pressure that that particular person and the identity groups that they represent are therefore spokespeople for that entire, cohort. And part of why Renee and I advocate so heavily for increasing the diversity on the court, and using a very broad definition of diversity is to lessen in part that burden. I think there's a danger in essentializing the experience of one person as representative of the entire groups that they represent. I am curious to get my co-author's take on this as well, or my co-panelist take.
I absolutely agree, and draw on my my own experience to authenticate your remarks. I mean, it's very accurate. I was appointed quite a long time ago, but then I sat on our high court for 20 years before another woman was appointed to the court. So while it had a lot of visibility and I think some impact, it was extremely lonely for me. And it was, I think, very detrimental to the court. And then, of course, when I left 4 years ago, I was replaced by a woman, which was very heartwarming. But then she was the only one on the court. We just had the second woman appointed to the court this week, and we're very pleased about it. And there's a chance, given the sort of short list in terms of the recommendations that came out of the selection committee, there's a chance that we'll get a third on our 5-person court. And there are other courts around the country who've gone through that same process. And there are still some courts in the country who haven't gone through that process and still have a one and only. So you're absolutely right about the tokenism. People have to take on the burden. And you can see, for example, in the case of Clarence Thomas on the United States Supreme Court, he's a Black man, and a lot of people have had enormous expectations of what a Black man should look like as a judge, and he does not meet most of those expectations. And I think it's created, he has different views, and is certainly, in terms of sort of mainstream activism, something of an outsider, and so, or at least mainstream racial diversity activism, because he's not a fan of things like affirmative action and so on. So he's had to walk a very lonely path, I think, as well on the court, and particularly since, Thurgood Marshall came before him. So you had two very different paths being pursued. But I think it's a real problem. And you don't just see it in the courts, you see it in law firms, you see it on corporate boards, you see it in politics. You see it everywhere. I mean, the only female governor we have had is someone who took over when she was lieutenant governor, and she took over when the governor moved on to another assignment. And it's kind of phenomenal when you think about it. A state as old as ours never to have elected a governor of the state. We've done better with mayors, although that's recent. And so on. Anyway, I think your comments are completely congruent with my experience and observation.
And we're still talking about firsts, right? Or with the appointment, of Judge Hagan to ascend to the Utah Supreme Court, getting back to 2 women on the court. We're not even talking about what does it look like when there's parity, or when women are the majority of the boardroom or the bench or whatever it is. The Utah Court of Appeals, when Judge Hagan was appointed in 2017, the press ran, front page article, because for the first time, the 7-member court was 4 women. And so it was the first time that there was a majority. And, my appointment would have continued that, and that didn't happen. And so it's back to 3 women and 4 men. So it's sort of interesting that, we're still talking about firsts, and there's a lot more to go.
I think there is an assumption sometimes that if a woman is on the court or a person of color is on the court, that they're going to vote in a particular way, that they share particular views with a constituency. And we've seen that is not necessarily true. Hannah, can you talk about the importance of diversity on a bench, even when folks might be voting in a very different way than what we might expect?
Well, I mean, I think we could spend an entire hour talking about why diversity matters. There's obviously a symbolic component to it, having especially a Supreme Court, but really any court that is reflective of the public that it ultimately serves is incredibly important. it's important for, my daughter and your daughters and our sons and, everyone to see reflections of themselves and also reflections of others who do not look like themselves in positions of leadership and power. I think very perhaps fondly this week in particular of Madeleine Albright, who said earlier in her career when asked, did you ever envision yourself serving as Secretary of State? And she sort of laughed and said, well, no, that was never really on my mind, in part because I never saw one, wearing a skirt. And so there's that piece. And then of course, having diverse perspectives that encompass a range of perspectives is essential. Justice Ginsburg, famously said that, and I will of course, not get her quote exactly right, but basically that our system of justice is richer for having diversity of opinions and perspectives and people on a court than it is, having everybody who's cut from the same mold. I mean, how boring would it be if there were 9 people who had my perspective in any, on any court or in any position of leadership or power. And I think also thinking about the way that we think about diversity, obviously race, ethnicity, gender, sexual orientation, identity are all important, but also it was very interesting to grapple with the idea most recently with President Biden's shortlist. Judge Childs went to a public university and a public law school. If she had been confirmed to the US Supreme Court, she'd be the only sitting justice who did not go to Harvard or Yale. And I think that there is something to be said for really broadening our idea of the kinds of perspectives and the kind of individuals and the kinds of backgrounds that are important, whether we're talking about the judiciary or elsewhere.
I was thinking about this morning. My mom was given a choice of being a nurse or a teacher.
Mm-hmm.
And when I was a kid, there were no female justices on the court, and I think I did okay. My kids have a teddy bear that they named Ruth Bader Ginsburg. Where are we, Christine?
Oh, we are so far from there. I love one of my favorite of Ruth's quotes was the time when someone asked her when she thought the Supreme Court would have enough women on it. And her reply was, I think when there are 9, we'll be all right. And I feel that way about, the work that we're trying to do here in Utah in the legal profession. It's important work, and I realize our state has its own issues and so on, but although women are majorities at one of the law schools and close to parity at the other, we don't just have the 2, the number of women in the Utah State Bar is somewhere between 28 and 29%, which is just crazy. It's not, and I, over the years, had so many law clerks come through, and the women, I tell my stories because I go way back and back to some of the really horrendous stories, and their eyes would just kind of glaze over. And then they'd come back to me in 5 or 7 years and say, I can't live the life I want to live in today's profession. The opportunities are just not there for me. It would often be around family issues. It would often be around promotion issues, the recognition issues, and those systemic kinds of barriers to women in the legal profession and to women getting on the bench. I mean, even now with all the progress, if you look at both the state benches around the country and the federal benches around the country, we're still somewhere around 30%. And again, that's with 15, 20 years of a pipeline that's been feeding that. So we've got a lot of work to do. I think books like Hannah's book and research that continues, we have much better information about demographics now. We know a lot more about what's going on, and I hope that will help us fix it, but it needs a lot of fixing.
I'm going to let Justice Durham's words close us out this morning. It's 9 o'clock. We have some comments in the chat box thanking our panelists for a wonderful discussion. I want to echo that. It's a wonderful book. I really enjoyed reading it. Again, Shortlisted, Women in the Shadows of the Supreme Court. Hannah, the website, if I'm going to get it right, is Shortlisted Book. Is that correct? .com.
Yeah.
Great. And I hope that you all will join us for our next book review. Dean Kronk-Warner will be back in April. It's Sexual Assault Awareness Month. And so she will be picking a book and having a book talk on that topic. Thank you again to all of you, both in the audience and our panelists, for coming today. It's been a pleasure having that conversation with you.
It has been a pleasure. Thank you.
Yeah, thank you. And thanks, Hannah, for the work, and to your co-author. And thanks, Dean, for putting this together. I appreciate it.
Yes, all of that.